Don Casey.
Yeah.
Hey, look, I need to have somebody who knows his background.
That being said, now I started reading about Agenda 21 back in 1992. Was very aware of NAFTA, and I ordered NAFTA and actually had it overnight shipped. I hadn't read anything, any books or any of any worth other than maybe a magazine since the time I graduated from high school. So when Perot and Clinton and everybody else came along in 1992, they would say talk about NAFTA, the North American Free Trade Agreement, and I decided, well, it's about time somebody looked into it. I ordered it overnight express out of Washington, sat down and read it, and I thought, boy, this is one treasonous piece of document. Naively thought that somebody was going to arrest some high official at some point. It took me a while before I came out of that naive mind frame. And as it turns out, it was exactly what I thought it was in the end. This is just one road for globalization. So from that, I've just been reading one thing after the other and learning all I can. So now this is just maybe a benefit for other people for what I have and what several other people have been able to put together. I sent Carrie the information that I wanted to pass out, and I know from experience, because I have been there, that seldom, if ever, is the information read. So that's just a given. So now I hope that this explanation of who we are within the system, which is the primary meat behind a quo warranto. In other words, when you create a legal document and you do not describe who you are within the system, then they may assign to you a specific category. You could become a person and assign privileges if you do not define who you are. And that's the whole point behind the Quo Warranto.
Before you get into that, let me assist your bio a little bit. Don Casey,
Get into the camera.
In case you don't know, is one of the experts in the United States on Agenda 21. Don knows as much in detail about it as anybody that I know of. And to give you an idea, Don and I went to Australia. We got invited to go over there by some conservative groups, and we did presentations in Australia for 12 days and spoke to the Parliament and a lot of the conservative legislators. I just got an email 2 days ago from one of those groups in Australia has passed their first resolution against Agenda 21. One of the state parties passed that, and they're working on several other states. And they said in the description of the resolution that it was based on the work done by Alabama and the United States and the anti-Agenda 21 bill we passed in 2012. So Don's being a little modest there. He goes all over the country teaching this stuff, and he's dug into the legal aspects of this now. And you're going to find this very interesting. Pay attention, folks, because you're going to need to know this. Mr. Casey.
Thank you.
That Australian bill actually referenced the work you've done in
The write-up that I don't know that the bill is based on our bill, but the write-up that they sent to me referenced it. I think it was part of the resolution, yeah. I'm not sure. But when we went over there, we didn't know whether these people were going to be able to put together a good campaign or not, and they ran our wheels off. I mean, we were busy every second we were there. And now they're awake. They realize that all this is coming from one common source. It's all Sustainable Development, Agenda 21, whatever you want to call it. And so Don did the majority of the work on the presentations, and I was just there for entertainment benefit and politics or whatever. But anyway, he is an expert in his field, as most of you that know him know that already. But anyway, if you dig into it, you can get things done. We got another battle coming up on this Common Core we're going to be working on later. But anyway, I'm taking Don's time.
Yep. This presentation really gets into a litany of various things that it can be applicable to. Common Core is just one of them. Sharia law, which I'll talk about in just a few minutes, but it covers everything. And it gets, like to say, the handout that I sent to Carrie is as printed, 5 pages long. And the majority of the information is about who you are first, and it's heavily footnoted. And we're going to look at that statement of who we are and then talk about the Quo Warranto. Now, Quo Warranto, as you'll see in just a few minutes, is a writ. It is a order from an authority to an underling wanting to know about what authority have you taken certain actions. And we'll look at that in just a few minutes. I run into people all the time that I ask them, well, what rights do you have? And they absolutely are stunned. They can't tell you what rights they have at all. And obviously, if you can't explain that you have rights, obviously you don't have any rights. It's just that simple. The first right that we forget about is the right of privacy, the right to be left alone, the right to travel. I don't, if you stop me for any reason, unless you have due process or probable cause, then you've interrupted my right to travel. And that's one of the that was such a fundamental right in the beginning of the country. They talked about putting it in the Bill of Rights, but they said nobody would ever impede our right to travel, so we don't even need to talk about it. So those are just some of those fundamental rights that we have that we don't ever think about. The term jurisdiction is often misconstrued because they think it is the boundaries of the municipality or county government or state government, when in fact it's the jurisdiction over a specific area. Now, you have a private jurisdiction that is above the jurisdiction of the created entity of government. So your jurisdiction falls under a different category and holds a higher status. And there are actually only 4 jurisdictions, generally speaking. Now, this is April the 18th of 1775, and the 4 jurisdictions in this particular graphic are first, of course, the Creator, and then we have the church, and then we have the state, who usually work together. Frequently, though, there was a lot of problems between the church and state. I know Henry VIII couldn't get a divorce, so he just set up his own church and then lusted after anybody he wanted to. So this was a problem across the centuries now. It goes all the way back to the Old Testament. And of course, the people wind up being the recipient of whatever the church and state wanted. Well, April the 19th of 1775, everything changed, and I do mean everything. We don't realize the importance of the legal system that was created off of what the people did on that day. Now, in this particular graphics, we again have the Creator, because we're just rearranging the jurisdictions. The Creator is always on top. He has extended to us unalienable rights. And I use that word, phrase that way, because I want to make the point that what the Creator has granted to us, no entity of man has the authority to place a lien against. Thomas Jefferson, who wrote the Declaration of Human Rights for the French Revolution, used inalienable, and if you look that up in a legal dictionary, you will find that those are rights which the possessor may give away. Our rights are not inalienable, they are unalienable. And extended to the people. This is a common noun. If you look at your state constitution, you will find that it references a common noun people. In other words, it references everybody in the state. And we have those rights extended to us. We are in a private jurisdiction, and if you look at Colossians 1, chapter 1, verse 13, you will find that God the Father, under His sovereign grace, has placed us under the jurisdictional authority of the love of His Son. This is all biblically based, every bit of it. And we are in that private jurisdiction. Then the people sent their representatives to state governments, and they, by constitution, created a state government where they transferred obligations and responsibility. Because what the Creator has granted to us, we don't have the authority to transfer. All we can do is look at that jurisdiction below us and say, your responsibility is to protect those unalienable rights granted to us by the Creator. Now, we have then the federal Constitution, which is one of the 4 organic laws, and it references a capital P, people, and it is the representative of the state governments to the federal governments, and they in turn transferred certain obligations and responsibilities to the federal government. Now, most people, as a matter of fact, Ken and I have talked to a number of elected officials, and we'll ask them, did the federal Constitution create the government? Or which came first, the state or the federal government? Invariably, they don't know the answer to it. So it's up to us to begin to educate as many people that go into office and make sure they know the very fundamental functions of government and what is the purpose of government. Now, Let me talk about Katz versus the United States, 1967 case, talking about private jurisdiction and where we are. You see, Mr. Katz went into a phone booth back in 1967. FBI wiretapped him and used that to gain a conviction against Mr. Katz. Supreme Court ruled that because he closed the door on the phone booth, he had a reasonable expectation of privacy, and they tossed out the conviction. So when we go onto our private property, the code enforcement officer does not have the authority to look into our jurisdiction and make certain judgments about it and then fine us for something that he thinks that we have caused a violation of his code. You see, we can't see into our Creator's jurisdiction and make a code or a restriction for what he has done. We have created a state government, and municipal government is under that. They don't have the authority to look into our jurisdiction and make a law that regulates what we can or cannot do on our private property. And John Jay, who was one of the first Chief Justice in Chisholm versus the state of Georgia, acknowledged that, because he said that the authority of the king devolved into each and every one of us. Now, it is that important point that we don't understand. We don't know how to use the authority of that king. We don't know that we stand on the Constitution and the state officers are under the Constitution. They have restrictions that we have laid on them, and we don't know enough about our own Constitution to hold them to that restrictions of the Bill of Rights within that state constitution. Now, Article 1, Section 35 has the policy statement for the people of Alabama. Ken, don't answer. Does anybody know what that is? I was over 50 years old before I knew that we even had a Bill of Rights in our state constitution. And the policy statement for you and I now to the state government says that the sole object and only legitimate end of government is to protect the citizen in the enjoyment of life, liberty, and property. And when government assumes other functions, it is usurpation and oppression. When they put a red light camera up and impede your right to travel, they have just enacted oppression and tyranny on the streets. When they send the code enforcement officer around to regulate what you can or cannot do, they have violated this policy statement. I'm hoping that tonight we can begin to understand how we can use that authority of the king that we have to regulate back into their restrictive box the officials of the municipalities or counties. Now, SB 96 is a law that was passed this past legislative session to the state legislature. And in SB 96, there is a policy statement. And I'm going to go over this policy statement. It says that the prevention and elimination of slums and blighted areas and economically distressed areas is a matter of state policy and state concern, in order that the state and its municipality and counties shall not continue to be endangered by areas which are local centers of disease, promote juvenile delinquency, and consume an excessive portion of public revenues because of the extra services required for police, fire, accident, hospitalization, and other forms of public protection services and facilities. This is a declaration by your representatives at the state level that counters the policy statement in Article 1, Section 35. Now, SB 96 goes on and says that we're going to authorize certain entities to redevelop the property and take public funds, put them in private pockets, and under eminent domain, we're going to have the authority to take whatever piece of property we want and redevelop it so we can protect the revenue stream for the city, the county, or the state. Doesn't make any difference. And that now is the policy statement in SB 96. Obviously, it is counter to Article 1, Section 35. I encourage you to read every one of those Bill of Rights in our Constitution. It pays special attention to Article 36, which is the last one, which says that our rights cannot be violated by the Code of Alabama. Now, let me go on now and talk about the Quo Warranto, because the Quo Warranto was the writ, the old English writ, which is an order written by the King of England to an underling, and he wants to know by what authority you have taken certain actions. Well, now, all of that common law now was written into our law. Alabama is a common law state. All of the authority now of the king devolved into the people, and here is what it says. A quo warranto is to ascertain whether an office holder is constitutionally and legally authorized to perform any act in or exercise any function of the office to which he lays claim. So that's very simple what we're doing here. We have the authority of the king, and this goes right along with section 36.590, I believe is the actual code. And I have the book out in the car, so if we need to go over it during the Q&A, we can do that. All right, now, in the beginning of this quo warranto that we're going to send to Arthur, which I am proposing that we should do, and I'm actually going over Alabama right now trying to encourage people to think about it, and during a specific week of September, the people that agree to it will write up a quo warranto, sign it, put it on public record, and then send it to him, and then we'll have certain other people that agree to call and ask him about what his plans are and how he's going to respond to the quo warranto. But in order to ensure about an understanding of who we are in the system, we have put together a statement of who we are, and now I'm going to go over that along with the footnotes. And this is, I'm encouraging what Carrie sent out is the attachment that we're about to go over. All right, I said myself, I'm Donald Casey, and I'm one of the people. That's footnote 1A. Now, footnote 1A says, in the preamble of the Constitution, we the people, small p now, common noun, of the state of Alabama, in order to establish justice, ensure domestic tranquility, and secure the blessings of liberty to ourselves and our prosperity, we invoke the favor and guidance of Almighty God. Now, think about this. When a judge sits there and says you can't use the word God in our courtroom, he has just violated the preamble to your Constitution, which is a restriction on what he can or cannot do. So this is something that can be used in a multitude of places and situations. That's footnote 1A. I have no known or unknown contract, license, franchise, or other written or oral agreement of any type which in any way abrogates, violates, disparages, handicaps, or limits my unalienable rights affirmed in, but not limited to, the four organic laws of the United States and the Republic of Alabama. Now, where are the four organic laws listed? And this is the code book. As a matter of fact, this is Title 1 through 4. This is the United States Code. And in the beginning of this book, there are four organic laws. And they are the Declaration of Independence, which was July 4th of 1776. That was more than a year after the people actually took their stand. In other words, there was no organizational chart. There was nothing that said, okay, you guys go out and stand on that green right there in front of this church, and the British are going to come up here and shoot at you. And once we do that, then we'll codify everything and we'll have it all written down. That's not the way it worked. It was what the people did, the common, ordinary individual, and the legal system now had to be rewritten in order to put the whole thing into some kind of format that we could go forward with. So the Declaration of Independence, which recognizes the Creator, was 1776. And then we have the Articles of Confederation, which actually created the United States government. And then we have the Northwest Ordinance, and then the Constitution of the United States, which was 1787. So that is the four organic laws of the United States. As a matter of fact, I know an individual that was in court not too far away from here, and he talked about the organic laws, and the judge says, you don't know what you're talking about, and it made him shut up. Yes?
Can you explain, I'm familiar with three of them, the Northwest Ordinance. Can you give a quick...
The Northwest Ordinance is the first ordinance associated with the territories of the United States and is still applicable to those areas such as Guam and some of the Puerto Rico.
Wisconsin, Milwaukee, Indiana.
Yeah, but it was originally written for the Northwest area, which was Ohio, right around the Great Lakes.
And the significance is?
The significance is it talks about the moral aspects of ensuring that the people have a moral background. You need to read it and understand that the purpose of government, as the United States saw it, was to ensure that the moral character of the people was upheld.
It also says that the Bible is the only book that can be used to teach morality.
That's right. Absolutely right. So when now we come down to the modern day and they want to disavow all this, well, they're disavowing what is in their very first code. So now let me roll on. The other one was the Republic, Alabama. We hear the democracy all the time when in fact no, it's Article 4, Section 4, the United States shall guarantee to every state in the Union a republic. So in that statement, I'm one of the people, and I'm here in Alabama, which is a republic, and it has to be because of the Constitution. All right. In recognizing that the Alabama Constitution adopted by the people is the supreme and paramount law, and that's footnote number 3. Now, the Alabama Supreme Court has said the Constitution is the supreme and paramount law. The mode by which amendments are to be made under it is clearly defined. It has been said that certain acts are to be done, certain requisitions are to be observed before a change can be effected. But to what purpose are those acts required and these requisitions enjoyed if the legislature or any other department of the government can dispense with them? To do so would be to violate the instrument which they are sworn to support. Now let me say that in the fight for Common Core, and I know a lot of you are interested in that right now, there is a whole administrative rules and regulations set up by the Department of Education. There was a film or a conference that was recorded here recently, a month or so ago, where they get into the rules and regulations that are applicable under state statute and administrative code. That administrative code is a violation of the Constitution. So this would work well for those that want to sit down and study and understand what a Quo Warranto might do to that regulator that wants to use his administrative code to rake you through the coals and require a certificate and fees applicable to your private school right here. And we'll go over that when we begin to talk about Common Core and what's going on with it. All right, now I'll pick back up with who I am. It is therefore the people's restriction upon the powers granted to the officers and employees of Alabama. And it absolutely is, and we've let that absolutely run away. While the legislature's broad governmental power is plenary in character, it is not absolute and is subject to the express restrictions in the Constitution. That's the Alabama Supreme Court. So that's what I'm saying to Arthur Orr. I'm saying this Constitution now is your restrictions on what you can and cannot do. Hence, the Republic, Alabama, is created under the authority and for the benefit of the people, and that the people, of whom I am one, stand upon the Constitution, and officers and employees of the Alabama stand under the Constitution, quite literally. I am just under my father's footstool, standing on that Constitution, and the officers of the state who have sworn an oath to that Constitution take that oath and ensure that my rights under his system are to be protected. And we don't know how to exercise those rights and restrictions against those individuals in office. Now, the Creator is greater than the creature. And this is another Supreme Court case from Alabama. Obviously, we are created beings in His image. We're not greater than He is. The state government is a creature created by us. It's not greater than we are in jurisdiction. Next, that all political power is inherent in the people and all free governments are founded upon their authority and instituted for their benefit. Again, that's Article 1, Section 2 of the Alabama Constitution. So now I'm going back to who am I in the statement. It says, with the aforementioned having been said, the state can do no wrong. Therefore, officers and employees of Alabama cannot commit nor shall they condone any wrong toward the people who created the Republic, Alabama. Footnote 7. Since the state can do no wrong, tort or civil wrong, committed by an employee is without authority, and the employee cannot set up a defense to escape liability that he is acting within his authority. This is the Alabama Supreme Court again making that statement. Justice, therefore, cannot exist when form, which includes but is not limited to labeling of communication, rules, regulations, or other semantics of whatsoever nature, is allowed to exist over substance. And that's what we've done. We have allowed the regulations to rule over substance, and we've lost justice in the system. Article 1, Section 13 of the Alabama Constitution, that every person, for any injury done him in his lands, goods, person, or reputation shall have a remedy by due process of law, and right and justice shall be administered without sale, denial, or delay. Those are our rights that we're just expressing to Mr. Orr before we get down to the final questions. Now, there's a final statement here. Mr. Orr, if you have any evidence contrary to that which is stated in this document, you bring it forth. And if you do, then we'll discuss that. But otherwise, I stand on that Constitution, and I want to know about the Quo Warranto. Now, I'm going to go over the 4 jurisdictions again. We've got the Creator, the people, state governments, and federal government, and it is the pecking order in our system, and we have a responsibility to ensure that it's reestablished and the people know about it. So let me pick up on a couple examples of how wordsmithing fall into this. This is SB 129, which passed a number of years ago. It's called the Limited Self-Governance Act. Several people may be aware of what all went on. There's 19 to 20 counties that have adopted this already. They take a code enforcement officer, put a gun on his hip and a pad in his hip pocket, and he goes out and writes code violations against anybody that he wants to. Literally goes onto their property, declares their property junk, and this is going on in a multitude of places, and it's going on right here in this municipality. So this is an example now of an understanding of where we are within the system. Now, and by the way, these laws are written so that the most important part is always first, and you usually have a definition at the beginning of each article. So you'll have the purpose and the definition within the beginning section. And this is Section 2A, except where otherwise specifically prohibited or provided for either heretofore or hereafter by general law or the Constitution of this state, and subject to the procedures and limitations set out in this act, the county commission of a county may provide for its property and affairs and for the public welfare, health, and safety. I'm a private citizen. I'm standing on that Constitution. I'm not public. I am in that private jurisdiction. All right, now, safety of the citizens throughout the unincorporated areas of the county by exercising certain powers for the protection of the county and public property under its control. It's controlling its property. I'm standing up here controlling my property. They're just telling you right here that they have no jurisdictional authority to apply their rules and regulations under SB 129 over your property. Now let me go on and talk a little bit more about this, because this is now Section 5D of SB 129. It says the powers granted to the county commission by this act shall not include any of the following. It says other general laws in effect on the effective date of this act or thereafter. Well, what was already on the books? Section 119 of the Alabama Code says, and the title of this now is Existing Rights, Remedy, and Defense Preserved. Here's what it says. This code shall not affect any existing right, remedy, or defense, and I'm going to conclude after the comma, of the people. So whatever is written in the code for the state legislature cannot affect your rights. And if we don't know what rights we have, we can't send a letter to Arthur Orr and ask him, by what authority have you written a policy statement that counters the Constitution? And that's exactly what the Quo Warranto is all about. Wanting to know by what authority he has written the policy in SB 96 and put it into law and sent it to the governor for his signature. Now, Section 5, paragraph D says, of course, the powers granted to the county commission by this act shall not include any of the following. And again, here's another section. Any use of private property which may be authorized under the Constitution and laws of the state. Frankly, there's several of us that read this when it came through the hopper. We didn't have enough presence of mind to understand the wording. So it's telling you right in the law that if there's a law existing on the books, it doesn't apply to you. Neither does it apply to any private property. And if you look at the Section 111, which is the definitions for the Code of Alabama, they're going to define 2 categories of property. One is personal and the other is real. In the Constitution for the state of Alabama, it is private property. And we don't understand the difference, sir.
Isn't our law trying to take and use the power of eminent domain to turn that private property into public property for the use?
No, well, not to public. Trying to take private property and turn into other uses of private property.
That's what I want to get at, you know.
That's correct.
What's the crux of the matter?
Right, and he also wants to ensure the revenue stream for the state. So you see that he, as an officer of the state, is looking out for the state's good being, well-being, and he's disregarding the people's.
So what he's doing, what his tactic is, and what's wrong is that he's condemning it by eminent domain and giving it over to another private entity.
Right.
But can he say, you know, that this is actually public land and we're going to lease this on out to the public, to private entity for, you know, management?
Well, if you go back and read SB 96, you'll find that they can take public funds and put it in anybody's pocket that they want to.
I understand.
So quite literally, anything would go.
Well, what I'm saying is what is the defense against that type of an attack?
Well, the defense, in my view, is not to look at the tentacle of eminent domain, but to look at the policy statement that he's laid out and ask him, by what authority have you done this? And if he can't come up with authority, in the Quo Warranto it says, what is the authority in the Constitution that allows you to write a policy at the state level that counters the Constitution? And if you do away with the policy, the rest of it goes away.
Well, too, they confuse the issue between public use, which is when you take a piece of land and build a highway on it, or you build a courthouse on it, that's bona fide public use. The difference between public use and the public good. They have bent the definition around to create this illusion of public good, whereby if it brings revenue into the state or it somehow benefits the public, then they have the right to do this. But they do not have the right to cross into the jurisdiction and take your private property. The only thing the Constitution allows them to do is to take private property for public use if just compensation first is paid.
Okay,
You talking about the U.S. Constitution? Or
No, state. We're talking state strictly here.
Don, I'm not trying to take and throw stones at you. My job, you know, in my 9-to-5 job, you know, is a lot of threat analysis, which means I gotta think like a rat sometimes, you know. So what I'm trying to do is I'm trying to look at it from his perspective, and he's gonna go back and say, you know, well, we've got precedent, you know, judicial precedent that allows us to take this, you know. So, and he's gonna, you know it, and I know it, you know, he's gonna come back with, you know, a bunch of case.
I'm gonna tell you to read the footnotes in this, because it goes in and talks about the Supreme Court rulings. The Constitution and its Bill of Rights are a firewall against the code. I don't care what he does. If it violates that Constitution and we allow it to be done, then it will be done. But if we don't stand and say you don't have a right to this, and we have, I don't know how many Supreme Court cases in this state that say exactly what I just said. It is a firewall, and that's a quote from one of the Supreme Court cases that says that this Constitution, and by the way, I just read you out of this, an existing law that's already on the books. Look at 119. It says that the right remedy and defense of the people are preserved, and that the code, however many, and there's over 30 of these books about this size that are the Code of Alabama, cannot violate the rights established in the Constitution. We don't exercise them, we don't have them. It's just that simple. Sir?
They empowered themselves with a little trick called TIF.
No, TIF is the end item that they want to create.
You're
The end item that they're gonna use to generate
I'm a
money.
commercial real estate agent, I know exactly what TIF
You-
is,
you-
and I know what it does.
You are talking about a tenet of the controversy. I'm talking about the policy. I'm talking about the wagon. And the wagon says they can't do it. And we are ignorant and we are allowing it to be done.
I started fighting that back in 1980.
TIFs have destroyed the state of California. Now, we don't want this to remain on the books. By the way, SB 96 would allow for eminent domain for municipalities only, did not include counties. So 455 came along with Representative McMillan and a whole, I can't remember the other representatives. They took out the phrase eminent domain. So now they're just going to take public funds and they're going to coerce or cajole the property owner into going along with this. And they now added the counties. So now we have the counties and municipalities that have this authority, when in fact they don't have the authority, because
That's my point.
that's my point.
TIF is not
Okay,
constitutional.
all right, so now, let me go and talk about the Quo Warranto. Well, let me speak this. We have Sharia law. We're going to have a constitutional amendment coming up on the next ballot, which passed this legislative session, that there's going to be no foreign law come into this state. It would be primarily aimed at Sharia law. But I'm sure that what's going to happen is there's going to be a federal lawsuit, and a Quo Warranto would be sent to the governor or whoever else is involved in this, to them saying that your office is on the line because you're allowing a jurisdiction that's not germane to Alabama to come in and tell us that we're going to strike that which we have put in our Constitution. And you can't do that. So I'm saying that we need to expand our thoughts about how to use this Quo Warranto. And SB 96 is just kind of a trial and exercise of beginning to understand that. Let me talk about Mayor Battle. He has instituted a Sustainable Development Comprehensive Plan. Adverse possession, as I'm sure Larry can tell you, if you have adverse possession over a piece of land for 20 years, your title to the property is protected under our system. If they write a policy that's counter to the Constitution and you don't say anything about it, after a certain amount of time, a judge is going to rule, you didn't object to it, forget it. You just don't have the right to come into my court and object to something that you should have done a long time ago. Doctrine of latch is going to be applied to that. So I'm saying that this is a situation where if we can get enough people to write up a Quo Warranto, put it on public record. We're not going to go to the court system first. We're going to do all this and put it on public record, in which we'll have undisputed facts. Now, as to what remedy we might want, and I was thinking about that on the way up here, it could be that if Arthur Orr comes out and says, well, I made a mistake, folks. I've just endorsed a policy that's been on the books for a number of years. I should have recognized it. I'm wanting to correct the situation. We, you, especially you, because he's your district, may decide, well, that's sufficient. If it's not, then we could decide to sit down with the Attorney General, express that we are a delegation of individuals from across the state of Alabama that have come to discuss with you the fact that you should bring charges against him and have him removed from office. There is a public law that says that 5 individuals can bring impeachment charges against any public officer. Now, that could be an avenue that we might want to look at. But at any rate, all of the facts would be undisputed before you get to the judge. All of this is laid out. Just one more thing and I'll get to you. Once the undisputed facts are laid out and a sufficient amount of time is recognized for undisputed facts, then under 201 of the Evidence of Alabama, we could invoke judicial notice. So that when we go to the judge, we say, here are the facts. We sent a Quo Warranto to this man. He did not respond, or he did not adequately respond, and we gave him ample time to do so. This has been all public. Everything is out there laid in stone, and we now want a judicial ruling based off of undisputed facts. We have a better case. I'm sure locally probably is going to rule against us. We just go right on up the line. This is about the last thing before the box that I certainly don't want to go to reevaluate our situation in our culture. Do you have a question?
Has Quo Warranto actually been tried in the state of Alabama, and if so, about how many times?
Oh, it has been tried. How many cases, I don't know, but never in this.
It's a whole field of law.
It's a whole field of law. An ultra-vires act is an act of an officer of a corporate body that steps outside the oath. Every corporation in the state of Alabama, their authority extends from the Constitution. And if it cannot violate the code of the Constitution of Alabama, if the officer of that corporation violates it, it's called an ultra-vires act. So Arthur Orr now has an ultra-vires act, and we would be using this Quo Warranto to make that stipulation against him that he has not acquiesced and acknowledged his mistake and now trying to correct it. And as such, now we're going to take whatever avenue. One of them, like I say, might be to go to the Attorney General. But it has never been used in this venue that I can determine. But it has been used against corporations, and there's several cases in the state of Alabama where corporate charters are pulled because the corporation's not acting within the scope.
Was it ever used against a city or other county government? Quo Warranto?
It can pull the charter for the
No,
county.
has it ever been used against a city or county government?
In this state, now I can talk of one specific individual that was the judge. Well, let me go back and tell you the whole story. The individual drives without a driver's license. He doesn't drive; he travels. And you know who I'm talking about. You may not know the story that I'm about to tell, but he is a wonderful individual that is well schooled in common law. So he, of course, got a ticket. He went to court and is in the city of Bessemer. And the judge, as a matter of fact, the whole courtroom was full of lawyers because they wanted to see what was going to happen at this particular situation.
Is this Snuffy?
This is Snuffy. Snuffy walks into the court, and the district attorney standing up beside the judge, and they jawbone a little bit about, well, we'll just lower the fine down to $50. And Snuffy says, no, I want to go all the way. I want to see this thing adjudicated. So, as it turned out, in the negotiations, they said, if we will sign a contract with you that will never bother you again with any traffic violations in the city of Bessemer, would that be sufficient? He said, if you'll put it in writing, I'll sign my John Hancock to it. So he did. The judge in the discussion wanted to know, are you going to go after our municipal charter under a quo warranto? And Snuffy said, no, as long as I have that contract. Now, has it been used to pull corporate charters for municipalities and county? Not to my knowledge. But yes, for other corporations. But they're all corporations. I mean, it is a corporate body. And it has a charter. The charter for the state is the Constitution. And the municipalities have a charter when they came into existence, and that charter has to be in alignment with the Constitution. Cannot be anything else. Because all authority stems from the people. That's what it says in the Bill of Rights.
You had made mention about, a federal lawsuit coming against this bill that we've got going against Sharia law, and I didn't catch that. Can you please explain that one more time?
Well, what's going to happen on your next ballot, you're going to have a constitutional amendment that says that we will not allow foreign law to come into the state system. All right. Specifically, as everyone generally knows, it's any foreign law, which would include Sharia law. Okay, so in this situation, I'm sure that somebody is going to bring a federal suit against the state of Alabama over this constitutional amendment. Now, I know that in Oregon, in the state of Washington, there were some lawsuits brought against the enactment of a constitutional amendment to protect private property rights, and the judge overrode what the people had voted for. In this situation, I'm pretty sure that there's going to be some judge that's going to say the vote of the people is invalid. We need to be able to know and understand how to prosecute a quo warranto against that judge should he do that, or against an elected official that wants to back up and acquiesce.
That would be a
One
state
key
judge.
question is, what's the federal reasoning and the argument for coming, having a lawsuit against us for doing this?
Well, I'm not saying that the federal government would bring the lawsuit. I'm saying some entity would bring the suit and probably wind up in federal jurisdiction.
The basis being, what is that?
Whatever basis they want it to be. I mean, a lawyer can nitpick a comma if they want to.
I was just wondering if you knew something that was going to be on out there that was
I have no idea. I have no idea how this is going to work out. I'm just saying the probability of having a lawsuit over our constitutional amendment is going to come about. I just, given the past history, it's just a given that that's going to happen. Now, what are we going to do? If we're like other people in other states, we just sit back because we don't know what to do. But we have that authority of that king, and we need to understand how to exercise it.
Could somebody like Carr, for example, you've got a Muslim pro-Muslim organization that says we have certain laws, certain, for example, one of the ones I've always heard about is from a butcher law. You know, how they butcher meat, for example.
That's right.
And so they say, based upon this amendment that you've passed within your state, your butchers can't practice this particular type of law that we want to incorporate with on the books for our particular freedom of religion. Could they approach it in that manner?
I have no idea how they're going to approach it. I mean, just be frank with you. There is no telling what ingenuity and creativity that they're going to use to do this. Just take your pick. But we're talking about, I know I'm talking about Sharia law, but let's bring it down to the red light camera. Do they have the right to impede your travel? And a quo warranto to that, and let me go back and talk about 116. 116, and I hope you're taking notes, says that if the money from your fine goes into the coffers of the state of Alabama or any entity under that authority, then it is not a violation of public law. Well, what is it? If it's not a violation, if you violate the Code of Alabama and it is not a violation of public law, then what is it? And I dare say it's a contractual situation between the victim and the guy that's extracting the money and operating in fraudulent attitude towards you. So this would be wonderful to use for the quo warranto for the mayor that has allowed this to be put in place. And then frequently you're going to hear, well, it's for public safety. Absolutely not. Where you look at the statistics, you put it in, you're going to have rear-end collisions and back injuries and neck injuries based off of that because everybody puts on the brakes because they don't want a ticket. It is not for public safety, so they can't use...
What went on to Albertville and Joey's?
Well, in the situation with Albertville, and by the way, if you want to rewrite and talk about what you might want to put in a quo warranto, you might want to think about the red light camera is a color of law situation because it's a municipal ordinance that has less authority than the state statute, which has less authority than the Constitution, so it is color of law in this instance. But in Albertville, we had a situation that was, 2 years ago, maybe 3. An individual, a code enforcement officer came to a guy's house, and I've got the pictures to show you if you want to take a look at it, charged him with having a public nuisance on private property. Now, I mean, the citation said public nuisance, and he tacked it to the guy's front door. A lot of times people go through their side doors in and out of their house. Well, it so happened this individual did go through the front door and caught the notice that was stuck on the front door. And it went on and it said that if you do not correct the situation that the code enforcement officer has sworn to within 7 days, your fine is, I think, $500, 90 days in jail, no, 6 months in jail. And if you don't pay the fine or go to jail for that stipulated amount of time, then we're going to put a lien against your property and sell it. And if you don't rebut it in 7 days, you waive all rights to an appeal, and you're presumed to be guilty. Now that's what it actually said on the document that was stuck on the guy's front porch. So now what we sat down and did, we wrote up a series of letters. The court date had not occurred. And by the way, when you look at this quo warranto, right under it at the top it says Matthew 5:25. Matthew 5:25 is a direct correlation to what the people said in the beginning. I'm invoking the guidance of Almighty God in everything I'm doing. And I'm here I want to know, Matthew 5:20, I need to explain that. You're going to resolve the issue before you get to the judge because you don't know what he's going to do. He may throw you in jail. So this was a situation now where the man had received a notice of public nuisance on private property. We never got to the...
Tell them what the nuisance was.
Wait a minute, bud. We never got to the issue of whether or not you could have a public nuisance on private property. Okay, so his court date's 2 months out. He sets up a series of letters in which he asked for 4 things. He asked for the accuser. He asked for the statement from the accuser of what damages he had suffered. then, by his actions. And then he asked for the witness, because it can't be the police officer, can't be the code enforcement officer, because they're a biased witness. And then what law or contract did I break? Well, they wrote several letters. The city came back and said, well, Mr. Adams, who is the code enforcement officer, makes the accusation. You're charged under so-and-so code, and we're not giving you any of the other information. So there's no controversy. In order for a controversy to exist, those four things have to occur. And remember, this is not a violation of public law. This is a situation where the money's going to go into the city, so it's a contractual situation. Now, the charge, growth harboring insects. He had growth harboring insects. His grass was no different from anybody else's. He lives in a subdivision. His grass was cut. It was just a code violation. This is to put money, this is a revenue stream for the city, just like the SB 96. So in the course of actions, he was actually arrested. There was no warrant for his arrest. And we have video of him being handcuffed and put into the police car, taken down. They did let him go. There is a due process lawsuit in the works against the city of Albertville. But it happens that because they didn't produce the four essentials of a controversy, that the city would not allow this individual to come before the judge. In other words, the lawyer for the city would always meet him in the hall and escort him into a private room and ask him, had he done this, that, or the other. Always talking about the tenets of the case. You were wanting to talk about TIF. You can't talk about the tenets of the case. You can't talk about a TIF. You couldn't talk about the insects, because the four things are there. There is no controversy. And so he would always say, until you give me those four things, we can't talk about the bite marks on the code enforcement's rear end. We don't have the bill of medical services provided for this individual because he was bitten. We don't have those four things. So they never allowed him to go before the judge, because they would have been taking a fraudulent act before the judge, and that would be a much more culpable thing than what was actually done to him. So in this aspect, and you've got this going on here in Huntsville, left and right, just really unbelievable. You've got a whole division of city government built off code enforcement. Chip in there.
Let me chip in this a little bit. We were sitting around having a cup of coffee and kind of lost track of time and got to the courtroom a couple of minutes late. And as we walked into the courtroom, the city attorney's up there saying, well, Mr. So-and-so didn't show up and we'd like to drop the case. Okay, well, he said, no, I'm here and I'm not dropping the case. Okay, they're doing anything they can at this point to get out from under this thing. All right, they had taken photographs of his grass, which was about 5 inches tall, but they were standing in his neighbor's yard where the grass was waist deep, taking the photographs. Okay, and so they never gave him back a satisfactory answer as to who the damaged party was, who the witness was, any of this other stuff. And when their attorneys started looking at it, they knew they couldn't win the case, and so they kept delaying, kept putting off all this stuff, and then comes January and February, and the frost killed all the grass, and then one day they sent him a notice and said, since you cut your grass, since the grass is laying down flat now, we're dropping the charge and the case no longer exists. These people did everything in their power to get out from under the case that they had started, because he had enough sense to defend himself. And if they had ever allowed his case to come before the judge, they knew that the precedent would have been established whereby the city of Albertville, or any other city for that matter, could not go on a private individual's property and tell him what he can do just because it happens to be in their city limits.
How many other people actually did pay the fine? Or anybody else?
Well, a lot of them, because it said right on it, if you didn't defend yourself before the city council, and just sending them a piece of paper didn't count. You know, they didn't stipulate what you had to do. But if you didn't do this within 7 days, you were automatically guilty, and you gave up any rights to defend yourself in future. So what happens is if they give you this piece of paper, and if you don't defend yourself, then you're guilty of the violation of the piece of paper. It's got nothing to do with the grass anymore. Now it's got to do with you didn't show up in 7 days to defend yourself, and so you're automatically guilty.
You're presumed.
How do you spell tyranny?
Oh.
That's exactly what it is.
That's
And
exactly.
They get away with this all over the place because people don't know that they can't do it.
Now,
What are the four,
there has to be an accuser. In other words, the city of Albertville or Huntsville can't make an accusation. I can't put the city on the stand and ask it questions. So it has to be an officer. An officer of that corporate body has to sign on the dotted line. It has to be a real live individual to make the accusation. Then there has to be a witness that accounts, yes, there was damage done to this corporate body or this individual by you. Then there has to be an accounting. What damages were suffered? I mean, we have to know in order, if we're going to make you whole for what damages I've caused you, you're going to have to come forward and list what damages those are so I can be assessed. That's 3. And then the 4th one is, was there a contract or was there a public law broken that is indicated on some kind of paperwork? And those are the 4 things that have to occur.
There had to be an injured party.
right, I understand.
There
that.
is no
Does there
injured
has-
party.
Does there have to be a witness to the
Certainly.
infraction?
Well, I
So,
mean,
you know,
well, I could walk up to a judge and say, I'm going to swear on affidavit here that you've caused certain actions to me. How is that to be accounted without a witness?
Okay. Fair enough.
So it's just very simple, those 4 things. And those 4 things were what were asked for every 2 weeks. This man would, by affidavit, and he put it on public record, sent it to everybody involved, wanted to know these 4 things. He wanted to resolve the controversy without using public funds. He wanted to, Matthew 5:25, and he cited Matthew 5:25. I want to resolve this without using my neighbor's funds to resolve an issue that shouldn't even be in existence. But help me do that now. Bring this information forward, and they refuse to do so.
Getting back to Quo Warranto, in the last 2 decades, has Quo Warranto, to your knowledge, been used in the federal court system?
I haven't looked at the federal courts. All I've done is looked at the state courts because this is a state issue.
So basically, Quo Warranto is a concept in Roman law which is carried forward into English common law. So wherever we have wherever we have a state that's still based on English common law, we can use Quo Warranto.
And it is actually codified in law. Now, if you get what Kerry sent out and look it up in statute, and I'm going to say it's 36. It may not be 36, but it's the second number is 6-590. It's listed, and what they did was they came in the footnotes for the annotated code. It says that where an issue is of constitutional controversy, a Quo Warranto is the proper venue.
Now, there was a time, and maybe not so long ago in terms of human history, where the United States Code was strongly based on English common law.
Yes. Well, as a matter of fact, if you go into the very beginning of the Code for Alabama, and the court cases say that where the statute has replaced the common law is going to rule if there's a controversy between the two. Because it is that the code is supposed to follow the general concept and instill justice, because the court system is to dispense justice. And obviously, the Code of Alabama, written at the request of our officers, cannot violate our rights. So now with that, we're in a private school right here. And let me pick up, and a Quo Warranto could be used against this. This is the Code of Alabama, Title 16. And this is talking about private schools. And private schools are institutions of any kind having a school in connection therein, except church schools as defined in 1628-1. And you need to go and look to see what a definition of a church school is, because I dare say that it's going to be all of this is going to be interesting before it's over with. Okay. Now, a private school shall register annually on or before October 10th with the Department of Education. And the information that they're supposed to provide is the number of pupils, the number of instructions, enrollment, attendance, course of study, length of term, cost of tuition, funds, value of property, and general condition of the school. Now, that's not being followed up until just recently. Now, you can talk about Bice and Superintendent of Education all you want to. He is merely doing what this code is telling him to do. And if he's in violation of this code, then he's in violation of his contract. We're going to have to do something about the code in order to make the administrative code and everything else fall in line with the Constitution. And that's going to take some study. This is, if you go down and defund or do away with Common Core, you still have this to contend with. And believe me, there's a lot more in here that deals with schools and private, and a private tutor is a homeschooler.
Read what it says about private tutors.
I mean, give my glasses back. Oh, oh, by the way, a private school is defined in the code, Article 1. Now, an interesting thing is always get definitions, because if you allow the people to apply what definition they have in their code and you don't look that up, then you're behind the 8 ball automatically. Now, let's see, the purposes of this article, the following words, terms, and phrases shall have the following respective meanings unless clearly indicated or otherwise. Private school includes only such schools as hold a certificate issued by the State Superintendent of Education showing that the such school conforms to the following. Now, I hope you caught what I just said. You're not a private school unless you hold a certificate. So it's wordsmithing. So what they were doing in this meeting that was on the internet just recently, they were assuming that, well, you think that you should have a certificate because you call yourself a private school, when in fact, the only way you're defined is if you come to us and apply for it. And of course, when you come to us and apply, then we're going to take a fee for that. I think it's $500. They haven't been doing this up to now. This Mr. Quo was hired 2 years ago to enforce the tenets of the legislation that had been passed a long time ago, and he's now in the process of doing that. So we've got more than just Common Core to look at. Now, let me talk about the policy. The legislative intent now, this goes along with the policy of SB 96. This is a policy that's been on the books for a long time. The purpose of this article are to ensure the prompt and regular attendance of pupils and to secure their proper conduct. Well, now, what does conduct mean? We think that it means that they're going to sit and listen. Well, we have data mining under Common Core where they're going to put a wristband and monitor heart rate, blood pressure, and skin temperature. Then we have digital recognition software that's going to look at each individual in the classroom to see if they're paying attention. Chairs that monitor posture so that when the teacher hits an important point, the student is in the proper posture. All of this is data mining. This is what this is referring to. What the policy that they set would have to do with that data mining, and you, the parent, are to ensure that those students have a proper conduct. So when I say you better get the definitions down pat, when you go into these rooms and know what the definitions are, these broad brush statements like this of policy need to be redefined. And it goes on to the next page and says that the principal is the only one that can allow absence. The parent is not allowed to have an absence. And without that certificate from the principal, then the parent serves, I think it was 90 days hard labor in the county jail for allowing their child to skip school.
That's on the books now.
That's on the books now.
Yeah, this happened to my ex-wife and I in Athens school system. My daughter had some medical issues. This was 2.5 years ago. She had some medical issues, and she missed 1 day more than what she was allowed to miss. And they were going to hold her back, and they were also taking my ex-wife to court because she was the one that lived in Athens. And what we wound up doing, now Samantha had made up all her work. Her grades were all A's. You know, she had made up all the work. All the teachers had signed off on the fact that all of her work was made up, but she missed 1 day too many, which meant they didn't have that butt in the chair and they weren't going to get paid for it. Was the whole problem. And they were taking the ex-wife to court, and she was going to have a healthy fine, and they were also threatening to put her in jail. And
we yanked Samantha out of the school, and she finished school, basically homeschool. We did it with a diploma, online school, and, she did her first semester in college when she was 16. So they will do it.
That's right. They have the authority on the state law, which is a violation of our Constitution. So now let me say what I'm thinking about is in the month of September, those people that have agreed to write a letter notarized, this is a quo warranto notarized, has to be put on public record, will mail within a specific time frame or this quo warranto. Personalize it if you want to. If there's something that you think that should be added, add it or take something out. Whatever you want to do. It's your document. We're in that private jurisdiction. You have the authority to write your document as you see fit. I encourage you to know what the heck you're putting your name on. You should definitely know that and be able to speak about it if asked. That is going to be a tenet that you're going to have to know and be able to articulate. Then during the week after, I would think that after Arthur Orr has received these quo warrantos, we have a certain number of people that call him from across the state and want to know what his response is. At that point, then the people that have sent the quo warranto, we may have a meeting to come together and decide what response has been made, if any, and what we should do as a next step. Like I said, one of those steps might be to go to the Attorney General and express what we think ought to happen. It could be that 5 of us would want to bring charges. I don't know exactly what would be on the forefront of that particular situation. But at any rate, if it is effective, then we can move to other officers of the state that have committed Ultra-Virus Act in their capacity as officers of the state. So
never got around to reading about the homeschool. I didn't see who it was talking about. He pulled his daughter out of the school and homeschooled her to finish her up. You're not going to be allowed to do that.
That's right. In this situation, they want a certificate. Let me go back and talk, because I've been looking at Agenda 21 and what it had to do with the school system back in the 90s. There was the certificate of initial mastery, as it was called. They've now revamped all that. That was under Goals 2000, but it's all the same program. And the Chamber of Commerce actually had a website up in Birmingham, and they were to be the liaison between industry and the school system. And they would ensure that whichever child got the plum job adhered to all of the sustainable agriculture or education, all the criteria. He got the certificate of initial mastery and he was able to get that job. Now you apply that to a region and you apply that to an industry that says it will not accept any application from someone that does not have a certificate of initial mastery, and you have a means of keeping people within specific areas. And there is within Agenda 21 something called carrying capacity. And within a certain region, there is a measurement of all resources to determine whether or not those resources are adequate for those individuals in that community. And if you're applying to go to some other community to live, then a carrying capacity would have to determine whether or not the resources are there for you. Do you have the certificate of initial mastery? Do you have a whole litany of things in order to allow you to move to that new area? Sustainable development. That's the whole nutshell. I mean, all of this is to implement a philosophy that will strip us of everything that the Bill of Rights says in the Constitution.
Don, it looks like you got things going. You've got some action going on up, with Arthur Orr. We need some coordination. I would like to apprise you that the Madison Institute is setting up a venue for teleconferencing across the state, across the nation, 25 sites at one time. It's free for you to use. It's just, where you can actually sit down and have a meeting and have 25 different teleconferencing sites, so you can actually help coordinate.
All right, well, that would be helpful. I want to have a one-on-one meeting with as many people as are interested in this, and I'm trying to do it in the month of August to get this ball rolling so that we can, whoever wants to do this, and I'll be in touch with Brazo or one of you guys in this area, and you can disseminate the information, and we can try to set it up. So I encourage you to read that Quo Warranto. I think hits home with most all of the issues. Larry, if you would give us input on what you might think about it.
I got a couple of legs to add to your bill.
Okay. Well, if we don't have any more questions.
I have one.
Yeah.
I homeschooled, my wife and I homeschooled 5 kids all the way through. And it's been a few years, I will admit that. But during the time that we were homeschooling, actually prior to when we started homeschooling, there was some district superintendents who were trying to go after church schools.
Mm-hmm.
And there was a real revolt here. And then with a lot of action and political pressure, the citizens got basically an exemption for church schools that only required church schools to notify local superintendents that Johnny or Janie was present, and that was it. And that was the only obligation that we had under homeschooling, because we used the doctrine or the thesis that if you are associated with a church school, in this case it was Covenant Christian Academy, then that was the only obligation that was the organization that sponsored was the covering would notify the local superintendent that Johnny or Janie was enrolled, and that was it. And there was some activity to try and abuse homeschoolers, but Homeschool Legal Defense Association pretty well knocked that down.
Well, I noticed.
So what has changed?
Well,
You want me to talk to that now?
well, let me say one thing, and then I'll go right ahead. The state law has been on the books since the 90s, but they
This was
have.
before the 90s.
Well, this, as far as I know, this was enacted sometime in the early 90s. It has not been enforced because the Department of Education did not have the forms. The paragraph that I read off to you said that the Department of Education was to present a uniform form to be filled out. And that now is in the works and will be presented, and all of the private schools that have their certificates and are declared private will have to send all of that information in, and it's going to cover homeschoolers before it's over with.
And including church schools?
Church schools, yes, most definitely.
Your
And-
news is loose right now.
And
That's why they're
Ken,
tightening the news.
Ken,
Now they've got this one.
to get in front of them. But let me say that the 501c3 corporate status of churches is going to be what is used to bring them into the fold, the churches.
Well, we homeschool our kids, and my wife is an administrator for a homeschool group. So we've been into this a long time. This guy that was hired by Vice a year and a half ago to put this up, they had a PowerPoint presentation, and they stipulated what their interpretation of the code was. And homeschoolers are going to be considered private tutors. In order to be a private tutor, you have to be a certified teacher in the grade and in the course you are teaching. Which means if you had 5 kids, like you said, and you're teaching them all these subjects, a homeschool mom is going to have to be certified in every course that she's teaching for every age that she's teaching, and when her kids get a year older, she's going to have to be recertified for that age. You have to have a minimum of 3 hours instruction a day, and you no longer just send a letter to the superintendent and tell him that your child's going to be homeschooled. You have to send a letter to a superintendent and request that he allow you to homeschool.
Sounds like California.
This is
exactly what
this is
we're
all
doing in
changing.
California.
And so this is a very bad policy. There is no way that the condition that public schools are in, especially what's going to happen to them under Common Core. Common Core, in spite of the fact they tell you it's supposed to elevate and be more rigorous, and it's going to, it's going to make our children brighter, it's not designed to do that. It's designed to dumb them down. But for instance, they take algebra from the 8th grade and they push it back to the 9th grade. It dumbs them down. Everywhere it's been tried, it performs more poorly than what we had before. But there's no way that public school, especially under Common Core, is going to compete with homeschoolers and private schools. And so we're always gonna be out there as an example of how it can be done better. Plus, homeschoolers, in most cases private schoolers, are actually taught real history, Constitution, constitutional law, and so they are an impediment to the propaganda machine for this huge socialist wheel that's trying to take over our country.
Well, I guess
So
I
they're
still,
gonna have to come after us unless we repeal Common Core and unless we go back and we have this law removed from the books. They're going to come after us. And see, this is what I call landmine legislation. For years, I'd go down to Montgomery and they passed some stupid looking law, you know, something. And I'd go ask the sponsor of the bill, why are you trying to pass this bill? He said, well, I realize it's foolish, but they'd never try to enforce anything like that, you know? And I'd say, well, if they pass it, somebody intends to enforce it sometime. So under Agenda 21 and Sustainable Development, these folks know 15, 20, 25 years in advance what they're going to need. And they have passed these laws, they're on our books, they don't enforce them. And so nobody knows about it or nobody fusses about it, and it lays there and it waits for its time. And when its time comes, they dredge it up like this and they start enforcing it, and when you start complaining, they say, what are you complaining about? It's been on the books since 1991. In effect, it has adverse possession. It's been there, nobody objected to it because they didn't try to enforce it. But this is all part of the same big game plan. They know what they need. They've already put a lot of this in place, and when they need it, they will reach in there and they will pull it out.
Let me pick up on a graphics from the Code of Montgomery. Montgomery, of course, Huntsville claims that they got out from under ICLEI, the International Council for Local Environmental Initiative, which is on page 55 of Agenda 21 and is charged with the responsibility to track and help local communities adopt the tenets of Agenda 21 and or sustainable development. Smart growth is part of that. Montgomery has already adopted the code. Huntsville has adopted a code, and this graphic is used in a great many places, and it's actually Table 1. It was adopted or amended in 2007, T1. Now, I don't know if everybody's aware of the Biodiversity Treaty, but it essentially says we're going to take 50% of the continental United States, set it aside for animals, 10% buffer zone, 40% of the remaining land masses where you're going to live and be authorized to live because you have a certificate of initial mastery. T1, there's no human structure. No human being enters T1. T2 is the rural zone, and as you come into the city, you're going to have stack and pack. You've got this in your comprehensive plan already. You need to be thinking about a quo warranto to your mayor because he's instituting various regulations to bring this about. It's just that simple. Now, let's say there was another point just about, go ahead, I got another.
The mayor said that they pulled out of ICLEI, they didn't sign ICLEI again this year. But I've read documents from the United Nations ICLEI people. They're getting a lot of resistance to Agenda 21 and to ICLEI, which is Local Agenda 21. And so they no longer list the cities and the counties that have signed on to this. If you go to the UN site now, then they'll say Alabama 6 sites or 7 sites, but they don't list them. They don't want you to know that they're actually operating under Agenda 21. And so they withdrew, at least in public, from ICLEI, but they're still following their comprehensive plan is laid out exactly according to Agenda 21 and ICLEI's regulations.
And the comprehensive plan for Birmingham lists a code enforcement officer for quality of life. And it says the quality of life police may be put in harm's way, so we need extensive training so that they can be protected as they go about their daily duties and enforce ordinances against you. The environmental police is already in Birmingham. They want to take that police force and move it over to the quality of life police. You're going to have the same thing. It may not be called the same thing, but it's going to be here. Sir?
2 things. One is that I actually read an article last week that talks about Obama saying, you know, and the title was, is Obama wants to move you into the cities, you know, and they were talking exactly The second thing is, you make mention about red lights, you know, and stoplights and everything. Our illustrious mayor in Huntsville has entered into an agreement with the people at Redstone Arsenal to move the training center for drones and you know, remotely piloted vehicles here in Huntsville. Now, what they're doing is they're making a training center. And so what they're doing, if you see the helicopters around here with big booms and everything, they're mapping every inch, you know, of this area, metropolitan area, and in Madison also. And so what they're gonna do is they're gonna have, as a training center, they have a Predator Hawk up there, they're gonna throw it up in the air, they're gonna have some guy at a joystick, and he's gonna be looking at you, and the unclassified, you know, figures out right now, they can track 65 people in a 10 mile by 10 mile square, 100 square mile area, where you can track 65 people individually, look at you, you know, over your shoulder, look at, you know, what you're reading in the newspapers, and track you. So this is, you know, you start talking about, you know, expectation privacy, you know. You know, these guys, you know, they're 17, 18-year-olds, you know, they're gonna be looking at people in backyards and things like that. You know, so.
This is not a good place to run that program. There's too many duck hunters around here.
Great day.
Well, you know, I mean, you know, they're on.
You can't see most of these drones.
Yeah,
Drones
they're
don't
shooting
quack
down
those
things
either.
flying 50
Well,
feet.
go ahead and finish your point.
Well, my point is that, okay, we've got a mayor who's done this, you know. You have people and citizens like myself who understand, you know, that this is a bad thing. How do we get this thing to a level and question and say, you know, under what authority can you do this, and how can we get this thing turned around? I know it's gonna be a problem, because he's gonna fight it, because.
Well, it is going to be a
jobs
problem.
and
But
everything.
let's say this, that's probably going to be a hard issue to sell to the general public. So you're going to need to pick up on something that's concrete, some issue that he has implemented through a comprehensive plan that instills some aspect of smart growth that you can point to and say, where is your authority under the Constitution, concurring statutory authority from the legislature and municipal authority in order to take this action? And that is going to be his Achilles heel. You're not going to be able to take a lot of these issues that you're talking about, because it's going to be sold as a job issue to help the economy, and it's going to be a difficult thing to say. So while we know that's an invasion of our privacy, you're going to have to take the issues that you know that you can act upon, create undisputed facts, and then go through the issue. But the first thing to do is to make it work against a public official. And not work against him. We want the public official to do what the Constitution says. We just want a government that obeys the restrictions, that's all.
But can an officer of a corporate body, you know, abrogate your rights to privacy, you know, through a contract with a third party?
Well, haven't I made it clear that they don't have the authority to violate the Constitution? Haven't I said that?
I understand, but that.
And we have Supreme Court cases that back it up. It's a question of whether or not we're going to have the gumption to do something about it.
Right.
Yeah, every one of these yard birds raises his right hand and puts his hand on the Bible and swears to uphold the Constitution of Alabama and the United States. And if you can prove that they're not upholding their oath of office, they can be removed from office.
And this has been codified in the state statute. It is a common law writ from the king. John Jay said all of the authority devolved into each and every one of us. We have judge, jury, and executioner all within our private jurisdiction. Somebody breaks into your house, you have the right to legislate the law on the books. He just violated my privacy. He is threatening my health. I am all of a sudden the judge to determine what execution should be implemented against this perpetrator. All of the authority of the government resides within each and every one of us, just as it did in the King of England. And Quo Warranto is codified in the state statute, mirroring that common law writ.
So what I'm saying is, I guess you were saying, you know, don't go down the road of Agenda 21, go down the road.
Going down the road that you can easily make this applicable and accomplish a task. That's the very first thing. Once you know the ropes, then you can venture out into other areas. But for this particular situation, we have a policy statement that says the state recognizes that the culture is deteriorating. And in order to prevent our revenue stream from dying on the vine, we're going to do specific things. We're going to take private property. We're going to put the rights to it in some private individual, expecting a revenue stream to increase.
God bless America.
God bless America. That is absolutely counter to what the Constitution says. The well-being of the state rises and falls with the citizens. It's just that simple. And the state does not have the authority to say, because we deem it necessary to protect our revenue stream, we're going to set apart upon the victims, the citizens that created us, and take their eggs that they lay, the fruit of their labor every day.
What's the backlash that we could experience?
I don't know. To my knowledge, this has never been done. All I know is that we have undisputed facts that's going to be laid out before we go to the judge. Other than the filing fees that would be required, I know of no repercussions. Now, Larry, you may want to speak to that.
Well, no, I was just gonna ask this question, you came up here to tell this audience about Quo Warranto. Was there something beyond that, like a specific application? Or are you just tossing out the idea?
I'm tossing out the idea. Now, we have an open records request with BICE and the Department of Education that they have not honored. They're in violation of the Code of Alabama. There's no limitation on time, but there's other things that we're looking at. One of them would be a Quo Warranto against BICE because he has violated his oath of office and has stepped outside that corporate charter that he had.
Who?
BICE is the Superintendent of Education for the Alabama. He is implementing Common Core, which is part and parcel of the whole ball of wax.
Well, is that this is my youngest one, so it's been a while, but is it basically what was Goals 2000?
Yes, it's the same thing. It's the same thing.
It smells like it.
Yeah, it is.
2020, it's all the same
It's
stuff.
all the same thing.
We've fought that for
Th-
7
This
years.
is, but Larry, let me answer the specific question. I know of no one in the United States that's tried this, but it has been codified. It is a venue that is applicable to this situation because this is a policy statement at the legislative level, and the code says that this would be the right venue to prosecute this situation.
So what you're trying to do is not develop, but perfect a weapon.
Well, it's there. It's already in the books. It was part of the common law. All we need to do is learn how to exercise it, and then we can use it against other things that may be germane to our particular area. But this is.
You gotta get your feet wet, try it a couple of times.
Thank you.
And then you become a little bit more proficient at it. And
That's
then
right.
it'll become a habit.
And this one is a no-brainer. He's got a policy that is absolutely counter to Article 1, Section 35 and 36.
Well, you need to know him personally to understand all that.
Well, I don't need to know him. All I know is that I'm in a jurisdiction separate from his, and he's written a state statute that is could conceivably affect me.
No doubt.
No doubt. But you're in the jurisdiction, so you may, certainly I'm encouraging y'all to take this and begin to understand the process. If we can't have numbers to do this, I don't see it going anywhere. If we could get 25 people to write the Quo Warranto from across the state, and then have, say, 100 that would contact him and want to know what his answer was, I think it would have great impact. And then if there was not a sufficient accounting for his actions, then we could go maybe to the Attorney General. We can choose whatever we want to do at that point.
So, number one, you need a strike team.
Need people willing to read it and understand it, and then if they feel compelled to sign on the dotted line within a specific time frame, mail that letter, notarized. It's got to be put on public record. All of this has got to be above board. Notice him of what he's done. Give him an opportunity.
What is public record? Where do you store the document?
The probate court. Go down to the probate court and put it on public record.
Yes, another
Oh, you file it?
What affidavit?
Do what, Larry?
Well, a lot of people want to do that, Don, they have some complaint or beef, and they want to go down
Right.
and record it in the probate judge's office. Well, that probate judge's office is to file documents that affect title to real property. You know, there isn't any real need to go out and, you know.
Well,
I got
in
clients,
some-
A whole bunch of people, they go run down to the probate judge's office, I don't record this affidavit, you know, the.
All right, well, would you have some other place that would be more applicable?
Well, hey, put it on the website.
Well, I'm saying, what I'm saying is that there is in the Code of Alabama, if it's on public record, you can make better judicial notice out of it. You have a better chance of making judicial notice
So
out
what's
of
the
it.
definition of public record?
I thought it was advertised in the newspaper.
Well,
A local
yeah,
newspaper.
I'm saying all those things may be something that you would want to do. But in some areas now, there is no public record in the newspaper. The newspaper's gone out of business. Huh?
We don't have a reliable newspaper.
Well, I agree.
They only print it every now and then.
You know, you may want to have a committee to come together and publish what you're doing in the newspaper.
They'll charge you $200 with an ad, though.
They charge $200 to drive down Parkway in front of their building.
So anyway, get together and discuss this.
Yeah.
Well, let me ask you this. And I'll sign your letters, I'll write them, I'll do any of that. But, and I don't care what the answer is, but what is the risk to the individual?
Yeah, that's,
I know of no risk.
Nothing.
Well, what I'm
yeah,
telling you is
there's
there
a
are people in
risk.
there going,
It's
well, I
work,
wonder-
which a lot of people don't wanna do.
He won't
It's
answer your phone.
sacrifice, it's doing a little something,
Well,
which
but Larry, there's
cuts
another,
out a whole lot of
part.
people.
There's another part.
It's
And
an
Obama
potential
uses it.
reprisals.
Yeah, Obama uses it all day, every day, or Holder does, and that is, if you make yourself public, you are attackable.
You're as old as I am. Now, you know that there can be reprisals that we can't account for.
That was the answer I was looking for.
I have no idea what reprisals may be coming, if it's really a dirty, think
Are
of.
you telling me to man up?
Wait a minute. Think of Phoenix City. What happened to the Attorney General in Phoenix City? It may come to that. I'm telling you, we're at the last straw of this republic.
I agree.
how much
I
is your
would tell
freedom
you
worth?
that
I thought it was an army.
in all likelihood, everybody in this room, Don and I certainly are, and Larry Decraft are, we're all on the top of the list somewhere. They probably got volumes
I
about us.
got 3 lists of big
We're
price
already-
on.
But let me just give you an example of what's going on. We've got an individual farmer who tried to help out a lady who was losing her land, and the bank involved in that, put him in a position where he went into bankruptcy. They destroyed his ability to make a living, foreclosed on his equipment when he was trying to make hay and trying to run his operation, so he could not pay the bank off, and they took his property. So, as he said, now I have nothing to do but learn and get even. All right, I walked in a courtroom, several of us over in Marshall County, been about a week and a half ago now, and I saw an attorney get up and walk up in front of the judge and plead with the judge to help him. And what he said was basically, this individual is pleading his case based on constitutional law. Now, a kid goes into law school, or a student goes into law school, first thing they do is give him an armload of precedent law to read. They never go back and look at the Constitution. They never look at the organic law. None of this stuff is ever based on the original document.
Case law.
So what you're having to do here is you're having to educate the judge as you go along, because the judge doesn't know this either. And this guy has kept arguing his case and presenting constitutional law, presenting Supreme Court cases, and the judge all of a sudden is beginning to open his eyes, and he said, you know what, if they sent me a Quo Warranto, I can't say where my authority is to do what I'm doing, because what I'm doing is against the Constitution. So this hayseed kid is beating the bank, the attorney, the courthouse, and the judge. And so this lawyer walks up and he says, Judge, basically, can't you do something? We've spent over $100,000 in legal fees trying to take care of this one little potato picker out here. Can't you help me out? I'm an officer of the court. Now, he didn't say these words, but he said, I'm an officer of the court. You're the judge. You're the officer of the court. We're supposed to be on the same team. And this hayseed's whipping my butt. Can't you help me? And the judge said, basically, no. He's right. He continued to on and on. I mean,
Well, but they're all complacent.
but what the point is, you're having to educate the judge, because the judge himself does not know what the organic laws say. And over a period of time, the Constitution has been so distorted that we're operating under the distortions rather than under the law.
And
But
that's
if
a
you've
great
got somebody that has studied it, and like Larry Beecraft said, if you're willing to go to the trouble to learn it and put the shoe leather into it and the time into it, you can win this thing. We can take our country back, but we can't do it. We're never gonna take our country back if we just sit around and knuckle under and say, you know, because right now what they do is say, you do it because we say so. And what this Quo Warranto does is it says, well, who gave you the authority to say so? Are you operating under the Constitution? Are you operating within the tenets of your office? Are you operating under what God said, the power of word that you had? Who says you have the authority to tell me to do this? So, but there's gotta be some place to start. You know, you gotta walk out there, you gotta pick up that little rock and walk out in front of Goliath and chunk it. And if you miss, maybe you can run long enough, chunk it again until you finally hit it.
He had 5.
Take a bunch of stones.
He had 5 stones.
Ma'am,
Is there any organization that's kind of, spiritual?
no, there is no organization, and I don't want to, this is a group of the people.
Well, the reason why I'm asking is I homeschool too, and if it hadn't been for the homeschool legal defense backing me, my focus was educating my children.
Right.
If I had to read all the laws and know all that stuff in order to do that, I don't know, that would have overwhelmed me.
Well, let me say this, the who I am statement should be every individual that graduates from high school in this country, let alone this state, should be able to articulate that. I should be able to list the 4 jurisdictions established in our system. These are just fundamental things. So I'm hoping that the process of doing this, you'll look at that statement of who I am, look at the footnotes that are applicable to it, and maybe do some more research. So this is certainly something that is worthwhile to learn. It will benefit everybody, from red light cameras to code enforcement officers.
Is your website up there? Show your website. And show,
Well,
is any of this on yours?
Our website is, none of this is on our website, and our group is not doing any of this. This is just a project that I think is worthwhile to get into, and I'm just,
It is.
Yes.
I'm just saying that it's something we all should know. It's codified in state law, and we have the ability to do it, and it's not that difficult.
Okay. Question answered. That's
Do
it.
you know about Tommy Battle and John Olszewski's $300 million office building at the gates of Redstone Arsenal?
No?
You need to look into it, but John Olszewski was.
Well, but see, it's not my jurisdiction. It's your jurisdiction. And you have the...
I've been fighting it for 5 years.
Well, how you fight it, though, never ask a public official.
I didn't know about Quo Warranto.
Okay, but there's some other ground rules. Never ask a public official an important question orally. Always ask it in writing. Always demand a signed written response. And I've seen written response that was scribbled on a scratch of paper, and you couldn't read any of it. So that's not worth the paper it's written on. If you don't get that signed written response, you have no response at all. So.
One last question for anybody that cares to answer. Last time I really paid attention to this was outcome-based education. Is this outcome-based education?
Same thing.
Same thing.
Yeah.
A+, outcome based.
Burst to death, guys, government's gonna take care of it.
If you can't bring if you can't bring your kid up to my level, we're gonna drag your kid down to their level.
All right. Don, I appreciate it. We got an announcement for 3 minutes here, and then I got